Hi, my name is George Bellis. I've been practicing law for over 40 years in many different jurisdictions, all kinds of cases, everything from class actions to products liability to business disputes. I've taken it upon myself within the last 8 years to learn a lot about e-discovery and how to apply it in litigation and in our practice. We've put together a series of lectures for ApexCLE on how to apply e-discovery and how to practice law in the 21st century. I hope you'll join us for those lectures. Today, we're going to try to give you a couple of goals in this presentation. The first one, I want to try to give you a little overview of e-discovery and some of the basic concepts. Number two, I'm going to try to review the federal rules and, more importantly, the principles that are being adopted by the federal court that now a lot of other states are adapting. And also, I'm going to discuss some evidentiary issues that arise with the use of e-discovery. And last and most importantly, I'm going to try to give you some practice pointers about how to apply e-discovery in the 21st century. So let's talk about metadata. Wow, what a great word. Nobody knew what metadata was 10 years ago, but now that's all the lawyers want to talk about is how do I see the metadata? Well, let's talk about what metadata is and what it means. It begins with the concept of what is a document today. The document is no longer a document. So, how do we authenticate e-evidence? What's the original? These are questions you have to come across. The purpose of getting the metadata in ESI is to be able to authenticate the document. So if you really have a question about the authenticity of the document, you need to get at the metadata. You need to get the original file. A printout of it doesn't do it. And if there's a question about it or the ESI has been destroyed, now you've got other spoliation issues. Those are questions that are going to be constantly confronting you as a trial lawyer.